If you are a victim woman of sexual harassment at workplace, or if a woman has complained of sexual harassment at workplace against you, this video is for you. In this video, I'll deal with all about the complaint relating to sexual harassment at workplace. Hello, I'm Advocate Nahush Khubalkar. I completed my Masters in International Law and I am a practicing advocate in India since last more than 31 years. So before we get deeper, you need to know the meaning of two terms. Number one, sexual harassment, and number two, an aggrieved woman. In fact, there are other important terms which you also need to understand, but for the purposes of this topic, understanding these two terms will suffice. First, an aggrieved woman. The term aggrieved woman might sound a bit complex, but don't worry. I am here to break it down into plain language so that you can grasp its significance. Think of the term aggrieved woman as a way to describe someone who has experienced something uncomfortable or hurtful. In this context, it refers to women who have faced sexual harassment and the law is taking their concerns seriously. This definition given in law has two parts: workplace aggrieved woman and dwelling place or house aggrieved woman. So let's break it down into one by one. Workplace aggrieved woman. Imagine a woman at workplace, regardless of her age or employment status. If she says that someone, let's call them the respondent, has done something that falls under the category of sexual harassment, she is considered an aggrieved woman. It doesn't matter if she is currently employed or not. The key here is that she is claiming to have experienced an act of sexual harassment. Number two, dwelling place or house aggrieved woman. Now, think about a woman living in a dwelling place or a house. If she works in that place, whether it's her job or part of her responsibilities, and she faces something that amounts to sexual harassment, she is also considered an aggrieved woman. In a nutshell, aggrieved woman is the legal way of saying that someone, a woman, has experienced sexual harassment. Whether it's at the workplace or in a dwelling place or a house where she works, her voice matters, and the law is here to address her concerns. Second term, sexual harassment. Sexual harassment is all about inappropriate behavior that makes someone, a woman, uncomfortable or unsafe. The law lists out various actions that fall under this category. These actions can happen directly or indirectly, and they include number one, physical contact or advances. Imagine someone touching you or making advances towards you in a way that's unwelcome. That's one form of sexual harassment. Whether it's a touch or something more, if it makes you uncomfortable, it's not okay. Number two, demand or request for sexual favors. If someone asks you for sexual favors, whether subtly or directly, and it's something you don't want, that's another type of sexual harassment. It's like they are trying to pressure you into something that's not comfortable for you. Number three, sexually colored remarks. Using words or phrases of sexual nature to describe you or others is also considered sexual harassment. This can create an uncomfortable or hostile environment, and it's not okay. Number four, showing pornography. If someone shares or shows explicit images or videos or content of a sexual nature without your consent, that's a form of sexual harassment. It's invading your personal space and boundaries. Number five, unwelcome conduct of sexual nature. That's a bit broader. Any behavior, whether it's physical, verbal, or non-verbal, that has a sexual element and makes you uncomfortable falls under this category. It's like any action that crosses the line and invades your personal space. So, Sexual harassment is a range of actions that make someone feel uncomfortable, unsafe, or violated. Whether it's unwanted touches, inappropriate comments, demands for sexual favors, or any other behavior with a sexual aspect, the law takes it seriously. So, having explained that, now I am diving into an essential part of India's Sexual Harassment of Women Prohibition Act. It's about complaint of sexual harassment. Section 9 of the Act is on my radar. Now, please don't really worry about these sections and their numbers and the complicated language these sections use. I may refer to some sections during my talk in this video, but it's okay if you don't remember them, unless of course you are a practicing advocate. I am here to break down the content and meaning of these sections for you in a friendly and easy to understand way. So imagine a woman facing sexual harassment at her workplace or a similar setting. The law calls her a aggrieved woman. She wants to take action, but she is not sure how to go about it. And that's where Section 9 comes into play. So, if a woman feels she has been sexually harassed, she can officially complain about it. She has to do this in writing. The complaint must be in writing, and I'll be dealing with it just in a short while. So the woman has two options. She can complain to the internal committee if it is set up, or to the local committee if there is no internal committee in place. So within what time can she file the complaint? There is a time limit. She has to file her complaint within 3 months from the date of the incident. And if there is a series of incidents, she still has 3-month window to file the complaint from the date of last incident. That means she can file the complaint within 3 months from the date of last incident. But wait, life can be complex. And sometimes there are reasons that prevent the aggrieved woman from filing a complaint within 3 months as prescribed in law. And that's why the law allows the internal committee or the local committee to extend this time limit by up to 3 more months. But while exercising this power of extending the time limit, they need to record in writing their reasons why they are doing it. And it's important that the complaint should be in writing. I'm coming to that now. Law says that if the woman can't write the complaint herself, maybe because of fear or other reason, the head of the internal committee, that means the presiding officer or a member of the committee, can help her put it in writing. This ensures she gets the support she needs to voice her concern. Now let me tell you a situation where the woman can't file a complaint herself. Maybe she is not physically or mentally capable, or unfortunately she is no more. In such cases, her legal heir, like a family member or someone who is authorized by law, can step in and file the complaint. So Section 9 is all about giving women a structured way to report sexual harassment. It gives her a reasonable time frame, assistance when needed, and even the provisions for alternate complaints in some special situations. Now, let me dive a bit into Rule 6 of India's Sexual Harassment of Women Prohibition Rules, because that rule is connected with Section 9, which I explained above. I am here to make it crystal clear, so just pay attention. This rule talks about how complaints can be made when the person who is faced with harassment can't do it themselves. Imagine someone is dealing with physical or mental challenges and can't make a complaint about sexual harassment on their own. Rule 6 comes into play to make sure their voice is still heard. Rule 6 outlines different scenarios where someone else can file a complaint on behalf of the person facing the harassment. Number 1, physical incapacity. If the person can't file a complaint due to physical reasons, then someone close to them, a relative, a friend, a co-worker, or an officer from the National Commission for Women or State Women's Commission can file a complaint. Or any person who has the knowledge of the incident can also file the complaint but of course only with the written permission of the person facing harassment. Number 2, mental incapacity. If the person can't complain due to mental reasons, a complaint can be filed by a relative, a special educator, or a qualified psychiatrist or psychologist, the guardian or the authority responsible for their care. Or this can be done by any person who has knowledge about the incident, jointly with any of the people I just mentioned. Number 3, other reasons. If the person can't file a complaint for any other reason, then someone with the knowledge of the incident can file a complaint, but only with the person's written consent. Number 4, death of the aggrieved. If the person has sadly passed away, someone who knows about the incident can file a complaint with the written consent of the legal heir. So Rule 6 is all about ensuring support. It's about making sure that when someone can't speak up due to physical or mental challenges or other reasons, those around them can still help by bringing the matter to light. So in simple terms, Rule 6 is a provision that allows others to file a complaint on behalf of someone facing harassment when they can't do it themselves. It's about ensuring that no one's voice is silenced. Now let me explain to you the further procedure according to Rule 7 of India's sexual harassment of women prohibition rules. So my wonderful viewers, I'll break it down into simple terms for you. So when the aggrieved woman or someone on her behalf files a complaint, she needs to give 6 copies of it along with any supporting documents to the complaints committee. That means the team responsible for looking into such matters. She also shares the names and addresses of the witnesses. Once the complaint is received, then 1 copy of the complaint is sent to the person being complained about. That means the respondent within 7 working days. The respondent gets an opportunity of 10 working days to reply to the complaint. The respondent can also provide documents, a list of documents, and the names and addresses of witnesses to support his side of the story. And the reason for all this is that the principles of natural justice should be observed. Principles of natural justice are such principles which ensure fairness in the inquiry process. I have already made a separate video for that on this channel. Please search it and watch that video. The complaints committee then starts an inquiry, making sure to follow the principles of natural justice. This means that the process is fair and unbiased. If the person filing the complaint or the respondent doesn't show up for 3 consecutive hearings without a valid reason, the committee has the right to stop the inquiry or make a decision without their participation. But they need to give notice of 15 days in advance before doing so. No party is allowed a lawyer during inquiry. Both parties, the one complaining and the one being complained about, can't bring a lawyer to represent them during the inquiry. And this ensures a more direct interaction. During the inquiry, a minimum of 3 members of the complaints committee, including the presiding officer or chairperson, need to be present. So in short, Rule 7 outlines the procedure for conducting an inquiry into a sexual harassment complaint. It's designed to ensure fairness, transparency, and a balanced process for all parties involved. So I hope this breakdown has made the filing of complaint for sexual harassment part clearer for you. If you found this explanation helpful, please give it a thumbs up and consider subscribing for more simplified legal insights. Thanks for joining me, and remember, supporting each other is crucial, especially in those challenging times. In the next video, I'll explain to you about the manner in which the inquiry is held and the action that can be taken during the inquiry. So keep watching.